very appealing for companies to incorporate there. They have very relaxed laws, the lowest rates in terms of the filing rates that you have to pay to file for incorporation. So Delaware has really lax laws, and that's why all the corporations, not all, a lot of them are incorporated in Delaware. Like if you're able to get jurisdiction in Delaware, the courts, the judges are very amenable to companies because that's how the state makes their money. Delaware is like the place. You should Google it. Like you want to incorporate in Delaware.
But you would think by now they would notice that the fact that so many of these businesses are just incorporating there for the purpose of lower tax rates and then having their principal places somewhere else, like International Shoe in St. Louis, Missouri. You would think they'd notice by now that that's creating numerous jurisdictional issues.
They are, but as we continue to go through the cases, you'll see they've already solved it. They've solved it. So in the beginning, they're like, what do we do? They're incorporated in Delaware, principal place of business in another state, and that's fine. They have a rule for that. It doesn't put anyone at a disadvantage anymore. But even with it, you not being able to circumvent personal jurisdiction by being incorporated in Delaware, you still want to be incorporated in Delaware. They have very low state taxes on corporations. Like it's fabulous. All right. Schaefer's like lawyer. Well, I can honestly say this is our last case. Only Schaefer and lawyer, and all the other cases are like normal, like International Shoe. This is the last one. All right. So let's talk about property bases for territorial jurisdiction. So we already know a lot of this from our reading of lawyer, which is good. Remember, very appealing for companies to incorporate there. They have very relaxed laws, the lowest rates in terms of the filing rates that you have to pay to file for incorporation. So Delaware has really lax laws, so that's why all the corporations, not all, a lot of them are incorporated in Delaware. Like if you're able to get jurisdiction in Delaware, the courts, the judges are very amenable to companies because that's how the state makes their money. Delaware is like the place. You should Google it. Like you want to incorporate in Delaware.
But you would think by now they would notice that the fact that so many of these businesses are just incorporating there for the purpose of lower tax rates and then having their principal places somewhere else, like International Shoe in St. Louis, Missouri. You would think they'd notice by now that that's creating numerous jurisdictional issues.
They are, but as we continue to go through the cases, you'll see they've already solved it. They solved it. So in the beginning, they're like, what do we do? They're incorporated in Delaware, principal place of business in another state, and that's fine. They have a rule for that. It doesn't put anyone at a disadvantage anymore. But even with it, you not being able to circumvent personal jurisdiction by being incorporated in Delaware, you still want to be incorporated in Delaware. They have very low state taxes on corporations. Like it's fabulous. All right. Schaefer's like lawyer. Well, I can honestly say this is our last case. Only Schaefer and lawyer, and all the other cases are like normal, like International Shoe. This is the last one. All right. So let's talk about property bases for territorial jurisdiction. So we already know a lot of this from our reading of lawyer, which is good. Remember that territorial jurisdiction again is based on property that's divided into either based on in-rem jurisdiction or quasi-in-rem jurisdiction, as we previously discussed. Remember, in-rem jurisdiction is where the property itself is the dispute. Legal dispute arises from the property itself, meaning it has something to do with the property. Who owns the property? Where the boundary? Have y'all had property class yet? Yeah. So like where the boundary lines are, stupid easements. I didn't like property either. Where the easements lie, like whatever. I don't even remember what easements are. Where are they?
It's like a driveway. Like you have permission to pass through the land, but not like own an interest in it.
Oh, you just started property.
Property too.
Oh, you should. You know easements.
We haven't done
Well,
afterwards.
Wow, yeah, that's really hard. So we only had property for a semester. So a year is not the norm. If you Google other law schools curriculum, it's just a semester. Civ Pro is just a semester too. Like this is a different type of curriculum they have here. But the thought of you doing property for 2 semesters, I think that's freaking problematic. Yeah. It's just I remember like was the rule of perpetuities. I understand now that I hated it then, and I remember that I hated it wasn't the easements, but it was
all of it.
Estates.
I like the landlord.
Estates and lands.
Estates, like freehold estates and
interest.
Future interest.
Actually, I was okay with that. I'll have to look at a property book and I'll be like, these things I still don't understand. I hate property. I just don't think it needs to be that difficult. Like, it's just
Who has time for
but
that?
don't tell me. We're actually friends. We can dinner with her. Mark. But she talks about Mark a lot, doesn't she?
No, she never talks about it. She likes movies. He's a professor here.
Oh, she talks about her dog Skip or something?
No, Wizard of Oz.
Wizard of Oz. So she told you she's from Kansas?
Yes.
Several times. All right. And remember, quasi-in-rem jurisdiction, the legal dispute is not about the property itself. They're just using the property in that state because they want that state to have jurisdiction over the case, so they attach the property, remember, at the onset of the suit. So I really want to stress, remember the quasi-in-rem. It's very important to understand Schaefer, but they attach the property at the beginning of the suit. All right, so we remember our territorial jurisdiction. Let's jump on in. So with the Schaefer case, we finally entered the 20th century, which I think is awesome. All the cases from the book until this point that discuss quasi-in-rem territorial jurisdiction were issued over 100 years ago, so this is great. They remained good law for about a century, so they had a pretty good run, and decades after International Shoe. And then this 1977 Schaefer case changed the law, but it had been in effect for quite some time before this. So either, I guess, Attorney Richter, since she gave the facts for the last case, do you mind telling me the facts in Schaefer?
Yeah. So Greyhound was apparently sued in Oregon for they had to pay some substantial damages for an antitrust suit and also a large fine for criminal contempt. So this one sheriff, a guy who owned one sheriff stock, who was not a resident of Delaware, filed suit against individuals within Greyhound, so not Greyhound as a corporation, but actually officers, and holding them accountable for having to pay the damages, which I'm assuming probably damaged the company's reputation and maybe the stock dropped again. And in order to try to gain jurisdiction over these individuals, he asked for their stock to be sequestered, which meant that the defendants would not be able to sell their stock.
Okay, so great. So we're not going to do the whole case in one room. Okay. But just after right on point, and you're doing a great job. Thank you for volunteering. Sure. All right, so I'm just going to do it again because we lose the facts, so we're not going to understand the case. So I'm going to slow it down just a little bit and just highlight what Attorney Richter said. Okay? How does that sound to you, Attorney Richter? Does that make you feel like you're there, or?
What do you mean, I'm sorry?
Being referenced to as Attorney Richter, like, is that like, oh, feel like you're there, or?
I'm not there at all.
All right, so we know Heitner is a non-resident of Delaware, so we have to remember, non-resident of Delaware. Files a shareholder derivative suit against Greyhound. Again, Greyhound is a Delaware corporation. So you have a non-resident defendant filing a suit against a Delaware corporation. The principal place of business is in Arizona. All right, so many of his officers in Delaware State Court, so he filed against Greyhound and some of his officers in state court, not federal court, upon basically alleging illegal conduct, right, occurring in Oregon, in which Greyhound was fined. So you're a non-resident of Delaware, right? You're filing a lawsuit against Greyhound. It's a Delaware corporation, principal place of business in Arizona. And basically you're saying they did illegal conduct in the state of Oregon, right? So Heitner alleged that the individual defendants basically violated their duties, fiduciary duties to Greyhound by causing Greyhound and its subsidiary, right? Subsidiary just means like companies that are underneath the umbrella of Greyhound, to engage in actions that resulted in the corporation being held liable for damages in a private antitrust suit, and they received a large fine. Okay, so essentially what he's saying is you all cost the company money because you didn't do your job, and I want to hold you accountable. Like the company shouldn't have to eat the cost for the fine that you got for the illegal conduct you engaged in. So we're basically saying, you know, these CEOs or whoever these officers are, you didn't do your due diligence. You didn't protect us. Okay, so is there any problem then with personal jurisdiction over Greyhound? Attorney Scalpa, let's go, Rob.
So like there were
Can it be in Delaware? It's easy. Like, does Delaware have jurisdiction over Greyhound?
Yeah. No.
Okay, is there any jurisdiction problems with Greyhound? Problems having jurisdiction over Greyhound?
Yes, because like the main like facility is in Arizona and like the charges were in Oregon, but I think the court says like Delaware does have jurisdiction.
So you know what you just did, which is like totally interesting, is you said no, and you said why, and then you said but the court says yes. So the court is the, they have the final say. So you said the right answer, but you gave it at the end.
Yeah, the court says yes.
Okay, so we know that there's not a jurisdictional problem with Greyhound. So just as a general rule, wherever you're incorporated, that state has jurisdiction over you. Okay, that's not going to change, even through the whole semester. It's nothing. Greyhound is incorporated in Delaware. It resides there. So she stated personal jurisdiction exists in Delaware. No problem asserting personal jurisdiction over Greyhound. So why are we reading the case? We're reading the case because someone is challenging personal jurisdiction, and it's the individual officers. They're saying, okay, fine, you filed this lawsuit in Delaware. Greyhound company is there, but we're not residents of Delaware. So remember, they filed a case against the Greyhound as well as its subsidiaries and its officers. So the Greyhound Corporation, yeah, you can file a lawsuit against them in Delaware, but the officers are saying, we're not residents of Delaware. We don't have any contacts there. Like, there's a problem. So they're challenging personal jurisdiction. And so how did the plaintiff then attempt to obtain personal jurisdiction over these officers since they are non-residents of Delaware? What did they do, Attorney Scalpa?
They were notified by mail with direct to their last known address.
Right.
And publication by a new council county newspaper.
So what you just described to me is how they were notified about the lawsuit. You just described service of process. I want to know how they attempted to assert personal jurisdiction over the officers. You know the answer. What kind of case is this? What kind of territorial jurisdiction case is this?
Would this be quasi?
Yeah, you know it. I wish you would say it like you meant to. But yes, you haven't said anything wrong in class. So quasi in So how did they attempt to assert personal jurisdiction? How did that?
So they tried to like sequester the property because they like had like some common stuff.
Yeah. So is anybody kind of like shocked about this? So when I first took Civ Pro, I'm like, oh yeah, there's property in the state. They can assert jurisdiction over the blah blah blah. They can attach the property. I'm thinking land when I was a student. I wasn't thinking, whoa, they're attaching stocks. Like, so if I have stocks in a company, they can attach these stocks as personal property. Like, I thought it was just real property. So I just remember for me, I was like, whoa, that's scary. So they attach their ownership of shares in Greyhound, right? This is quasi in rem again because the lawsuit in this case is about the shares. Remember, it's about a derivative lawsuit for violations of their fiduciary duty. And so the shares are attached at the beginning of the lawsuit so they can satisfy a judgment against the defendant in the case of the plaintiff wins. So instead of attaching real property, they attach these stocks, okay, personal property. Remember, for lawyer again, we attach it at the beginning. Why does the plaintiff try to obtain jurisdiction in this manner instead of some other way? Well, because the basis for jurisdiction, other bases of jurisdiction weren't available. Personal jurisdiction, in rem wasn't available because again, the dispute wasn't about the actual stocks. General jurisdiction wasn't available, which you don't have enough facts. But just know that this was the only way they could hold these officers, hopefully, under the jurisdiction of Delaware by attaching these stocks. So could there have been general jurisdiction over the officers? Again, which requires substantial contacts. The answer is no, because again, the officers were not residents of Delaware, so no residence jurisdiction, and clearly not enough contacts for general jurisdiction. So what about specific jurisdiction? We remember that specific jurisdiction means the cause of action or the dispute arises out of the defendant's contacts with that state. So in this case, it would be with the state of Delaware. So the reason that the plaintiff could not obtain personal jurisdiction based on specific jurisdiction is why, either Attorney Rickman, why couldn't they obtain personal jurisdiction using that specific jurisdiction?
Let's see, specific jurisdiction, they need to have minimum specific contact.
So did the suit arise out of the plaintiff's contact with the state of Delaware?
No.
Exactly.
Right,
Oregon, right?
it was in Oregon,
Yeah.
and then, yeah, it was in Oregon.
Okay, what was the other thing you considered? What about purposeful availment? Remember that?
I guess in that context, the Greyhound was doing.
Yeah, Greyhound, yeah. What about the officers?
Yeah, the officers weren't tied in with their, right. So this is really the only, this is kind of like their strength to try to attach them to Delaware somewhat.
Yes, absolutely. Okay, so we know the first requirement of specific jurisdiction again is that the plaintiff's claim must arise out of the defendant's contact with the state. This action likely did not arise out of those contacts with Delaware. Again, it arose out of the illegal conduct that was done in Oregon. Again, no purposeful availment to the benefits of Delaware, unless you count being employed by a Delaware corporation as enough, which usually that's not enough. Court says it's not enough that you have to be employed by a company in another state. No minimum contacts, and it's hard to make a fairness argument that it would be fair to require those officers to come to Delaware to defend themselves. When we get to another case down the line, they're actually going to give you 5 factors to determine if it's fair. So right now, we're just going to say it's not fair. Those are 5 criteria that you use. Okay, so why sue in Delaware? Couldn't they just sue each of the directors in the states where they live? Like, won't that solve the problem, Attorney Scalpa? Why not just sue each? Remember, whatever state you're domiciled in or resident in, that state has jurisdiction over you. So why not just sue the directors in whatever states they were from?
I mean, I feel like that's just. I mean, for like this like company is like based or like it's headquartered.
It's not in the book. It's just a practical. Why not just sue them all individually?
I mean,
What's the disadvantage of that?
Money.
Yeah, it's super expensive. So now I gotta get an attorney in each state where an officer is. I gotta and you run the possibility of getting inconsistent outcomes. One state maybe you want one outcome that's binding on everybody. So it's not efficient financially or logistically to sue the directors individually in the states where they're domiciled. Remember that one of the prerequisites to quasi-interim jurisdiction is the presence of property, right, in the state. So where the officer's stock certificate is physically located in Delaware, Attorney Richter. Were they physically there?
No.
No, they're probably located at the officer's home or a bank somewhere. So then, how is this property actually located? And it should be on the 3rd paragraph. The answer to that on page 94. So how is the property located in the forum?
It says because according to the Delaware law,
Yes.
it makes the situs of ownership of all stock in Delaware, it makes Delaware the situs for all stock of Delaware Corporation.
Okay, so they've got a state statute that says if you're incorporated in Delaware, the stock, wherever they physically may be, for legal purposes are going to be considered in the state of Delaware. Okay, so that's where that came from. There's a statute. And every state has a different statute. Delaware, again, that's their particular statute. Okay, so we know then for, again, the stock certificates would be considered located in Delaware regardless of where they are based on that statute. So what's the defendant's argument in this case? The defendant makes two arguments. They say, look, they weren't given notice of the attachment, so personal jurisdiction isn't valid. And second, even if the attachment was valid, meaning the attachment of the stocks to assert quasi-interim jurisdiction, there's no personal jurisdiction over them because they still don't have minimum contact with Delaware. So that's the defendant's arguments. They're saying, look, we didn't get notice of the attachment of the suit, and even if we did, it's still not enough because we don't have minimum contacts with Delaware. So this is a big deal because think about this. Prior to Schaefer, this is the whole crux of the case, for years, over 100 years, to use quasi-interim jurisdiction, all you have to do is have property in the state and attach it at the onset of the litigation. Now the defendants here are saying, don't I need minimum contacts as well? What about SHU? So now the court's like, wait a minute, should we apply minimum contacts requirement to quasi-interim as well? Or do we leave it like it was? Quasi-interim, all you need is land in the state, you're attached at the onset. Defendants are saying, no, that's not fair. We should have to have not only property in the state of Kentucky, but minimum contacts with the state of Kentucky. So that's why this is like they're trying to change the law this again. So essentially what happens is at trial, both the trial court and the Delaware State Supreme Court reject those two arguments. They focus mostly on the first point and much less on the lack of personal jurisdiction point. The Delaware court basically says that for interim and quasi-interim jurisdiction, you don't need to satisfy minimum contacts. Okay, they say you don't need it for quasi-interim or interim. But the Supreme Court basically said the trial court and the Delaware Supreme Court focused on the wrong issue. Why do they have just leave it alone? Like, do they have to come in and rock our boat? Leave it alone. You said it doesn't apply, leave it alone. But nope. Supreme Court comes in and they say, look, Delaware court system focused on the wrong issue. The court finds no personal jurisdiction over the individual officers in the Supreme Court, notwithstanding the attachment of their shares in the state. So part 2 of this case poses the question, should we require minimum contacts as a part of quasi-interim jurisdiction? Part 3 of the case then goes on to answer that question and says that we should. You're confusing me. All right. So even though Schaefer is a quasi-interim case, a case about someone trying to assert personal jurisdiction by attaching property, part 3 first examines whether an expansion of the international SHU to require minimum contacts to every type of personal jurisdiction, how that would affect interim jurisdiction. So essentially what the court's doing is they're saying, let's just think about this. How would it affect the different types of of jurisdiction if we apply minimum contact requirement to everything? So Justice Marshall concludes, he said, you know what, I think we're making a big deal out of nothing. I don't think it's going to affect anything, right? He says because the property itself, if that's the source of the dispute, then it's pretty hard not to have minimum contacts there. You own property there, so you're availing yourself to the benefits of the state of Kentucky. So basically, if you're a property owner, it's pretty easy to make the argument that you have minimum contacts. So I don't think it's going to make that big of a deal, he says, if we require minimum contacts, for instance, to interim jurisdiction. And again, interim is when the lawsuit is about the dispute about the property itself. He said also that the property itself would be a contract and would prove the defendant's purposeful abandonment of the state. Plus, he said the big interest in the marketability of property would likely satisfy the fairness prong, meaning the fact that most of the witnesses are in the forum state, it would be inconvenient to have you defend a suit in a state where you have property. So Justice Marshall basically concludes that requiring minimum contact for all personal jurisdiction cases would affect the exercise of in-rem jurisdiction. Can you think of a scenario where the minimum contact approach would change the results in an in-rem jurisdiction? And I'm going to give you a couple of examples. So again, where using minimum contacts for an in-rem action would actually change the outcome of the case. So most involve personal as opposed to real property, right? So Justice Marshall's right in that for in-rem cases, meaning they're involving land, the minimum context test won't change things much, right? But it might for personal property because personal property is movable, okay? So yeah, he's right. It's not going to change it if it applies to land, but it will change the outcome if it applies to personal property again because it's movable. And if you can move personal property around, there's a less of a chance that you might have minimum contacts with the state where the personal property is located. So I'm going to give you a hypo to show you what I'm talking about. So say that you and I both live in the state of sunny California. Okay, we live in California, and we're having a dispute about a Rolex watch, very pricey watch. Okay, I take the watch to New Jersey, where you've never been. Okay, I take the watch in New Jersey. I file an in-rem action to quiet title the watch. Okay, in New Jersey. Under the old Pennoyer test, personal jurisdiction is proper. Why? Because the property is physically the watch in the state of New Jersey, right? So New Jersey presently has power over the property. But under the minimum contacts test, personal jurisdiction is probably absent because the defendant, meaning you, have not purposely availed yourself to New Jersey law. Like just because I moved the property to New Jersey, whether it's a watch or a boat, that's not fair to say now you have contacts in the state of New Jersey, right? So your contact with the state of New Jersey is not enough for personal jurisdiction. So it matters if you move property around that's in dispute, whether or not you're required to show minimum contacts. It does matter. Does anybody not understand that? So again, if the property is land, yeah, you're there and you're enjoying the benefits of the state. You're paying property taxes to the state on the land. But if it's movable property, I can move that property to Idaho and then file, hey, I'm in the boundaries of Idaho. I'm going to go ahead and do a quick quasi-in-rem and I'm going to file a lawsuit. And you're going to have to come to Idaho to dispute this watch. That's a problem. I don't have any contact with Idaho. But based on the old law, it doesn't matter. It's within that state's boundaries, and if the property is in that state's boundaries, that state has the power to assert jurisdiction over any property, whether it's real or personal, within their state. This is complicated.
So is there going to be a case to answer that question?
No. So just hold your question. So I'm almost there. But no, there's not. This is one of those times where we're not going to have the real answer, unfortunately. Sorry. It's all. So what are the arguments against applying the minimum contacts to quasi-in-rem and in-rem cases? The ones that Marshall and the rest of the majority consider but reject. So here are their arguments. They basically make 3 arguments. The first one is they say, look, you need quasi-in-rem jurisdiction without minimum contacts to stop a debtor from avoiding the debts by moving or keeping his property in a state where they lack minimum contacts, right? You don't want them evading the process. So again, the first argument the justice makes is that you need quasi-in-rem jurisdiction without minimum contacts to stop a debtor from avoiding his debts by moving or keeping his property in a state where he knows he lacks minimum contacts. You see how quasi-in-rem jurisdiction without minimum contacts avoids this. Wherever you find the debtor's property, you can sue him as of now. So the court responds to that argument and says, look, they say that argument is not a good enough justification for us to change the law and require minimum contacts. Then in a response that's edited out of your casebook, and I think it's important for your understanding, the court says you can get property anyway after you get an in personam jurisdiction judgment in another forum where the debt is located because of the full faith and credit clause. They're saying even if you can't necessarily get jurisdiction in that state where the property is located, if you get a binding judgment in a state that does have personal jurisdiction, I can still go back to New Jersey or wherever, and that state has to, I'm still gonna get my money. They have to honor that binding judgment. So yeah, you may not be able to get personal jurisdiction in the state where you want to hold a suit, but there is a state that will have personal jurisdiction at the very least wherever they're domiciled. So they're saying it's not gonna put you at a disadvantage. It's not enough of a reason to change the law because it's not like you can't get legal redress, right? It's not like you can't get a judgment and then take it to the state where you reside and have them enforce it. And so they said maybe they would make an exception, consider for someone that's deliberately hiding assets, like moving personal property. So maybe he's like, if we change the law, maybe we should just make an exception for people trying to take advantage of it. And they said maybe this means that you should be able to attach the property even without minimum contacts, but not that you're able to use this attachment to require the defendant to come and defend themselves. So the court's kind of like basically saying we consider the arguments, but we don't think they're compelling enough to change the law and require minimum contacts for quasi and rem. The second argument against minimum contacts for quasi and rem is on page 97 in the second paragraph. And essentially what they say is, you know what, quasi and rem and in rem cases, they're super easy to test. They're the bright line rules, very simple. If there's property, is there property in the forum? State, yes. And so they're like, that's much more simpler than now saying, well, do they have minimum contacts? They're like, let's not complicate things by adding this minimum contacts requirement for in rem and quasi and rem cases. Leave it like it is. It's real simple right now. It's a bright line rule. Is there property in the state? Yes. Well, you can attach that property at the onset of the lawsuit. So they're like, we don't see the need to make things more complicated. And the court's response to that is, he said it's not totally, I'm trying to figure out which justice, it's Justice Marshall. Right. So Justice Marshall's response to that, meaning it's already a simple rule, leave it alone. Marshall says that even if quasi and rem jurisdiction is an easier test to apply, the cost is too high since it allows personal jurisdiction when it would be fundamentally unfair to do so. He said, in other words, simplicity is overrated. He's like, so I don't really care that it's easier test. I care about the test that's going to ensure fairness, right? The third argument against applying minimum contacts test to quasi and rem jurisdiction cases is simply that, it's history. Quasi and rem jurisdiction has existed for over a century. So the court's saying, look, we've always done it this way historically. Why rock the boat, right? And the court responds to this on, I believe, the third paragraph on page 97. They say, yeah, fine, for some it is, but the majority of Schaefer concludes that to continue quasi and rem jurisdiction without minimum contacts, would only support our continued acceptance that we're going to allow the process to be fundamentally unfair simply because we've always done it that way. So they're like, just because we've always done it that way, the justices are saying doesn't mean that it's the best and most fair way to do things. So all of that is to say, to answer your question, so the court in Schaefer rejects, they reject the justifications for quasi and rem jurisdiction. Fourth paragraph, page 97, 1, 2, 3, 4. On page 97, they say, quote, and this is very important, all assertions of state court jurisdiction must be evaluated according to the standards set forth in International Shoe in this project. On page 97, the court says, all assertions of state court jurisdiction must be evaluated according to the standards set forth in International Shoe in this project. Now, we don't like this statement. You know why we don't like it? Because the statement is broad, and some have interpreted this statement to mean that minimum contacts test also applies to in rem and quasi in rem jurisdiction. I think that's a logical interpretation. It says not some, but all assertions of state court jurisdiction must be evaluated according to the standards set forth in International Shoe. But others say that statement is just dicta because the Schaefer case was about quasi in rem jurisdiction, and so the minimum contacts test only applies to quasi in rem and not in rem jurisdiction. So they're saying that's not even what the case is about. So the judges are only allowed to interpret law or make law. I hate to say make law, but to make law based on that particular. What is the case about? You can't have a case on what's a good example on breach of contract scheme and then make a ruling on a tort issue, right? You can't just, so they're saying this wasn't even an in rem case. So it's just dicta. And dicta just means sometimes the justices like to show how smart they are. They just like to give their opinion. And they're just kind of percolating and saying, oh, I think this, even though it's not binding. So they're saying it's dicta, it's not binding, right? So that's a problem. Some people interpret that you do now need minimum contacts to apply to quasi in rem jurisdiction. Other people say, no, that's not binding, what they said, because the case wasn't even an in rem case to begin with. It only applies to quasi in rem. So the court goes on in part 4 to conclude that based on this new test, there's no personal jurisdiction over the defendants and their officers. The court basically reverses the judgment of the Delaware Supreme Court. So we have Powell's concurrence here, and I think it's important to highlight. Basically what he says is he doesn't want to decide whether minimum contact should be applied to quasi in rem jurisdiction cases. He says perhaps when quasi in rem is based on the attachment of personal property versus real property, that the minimum contact test would be irrelevant. In those cases, he said we should just use that bright line rule: is there property in the state, and move on. So basically, what he says is he agrees with the majority, like the stock certificates in Schaefer, and that he just doesn't want the rule to apply to real property. He says it should only apply to property that can be moved, meaning requiring the minimum contact test. So that's what Justice Powell says. He's like, I think we need to for quasi in rem because that's where people can manipulate the jurisdiction process by moving property to a state where they know someone doesn't have minimum contact. But he said I don't think it should apply to in rem cases. Okay. Then we have Justice Stevens' concurrence. Justice Stevens says, look, I agree with Powell, and he says he doesn't like the breadth of the opinion. It's too broad and encompassing. He said I only want to decide what's necessary to decide in this case. And so he's a little concerned about the notice provisions in the Delaware law. He's concerned about whether or not it's constitutionally fair or sound, if it violates the process. He states that one who purchases shares of stock on the open market can hardly be expected to know that he has thereby been subjected to defend themselves in that state wherever the stocks are legally located, not physically, but legally. And then you have Brennan, so they're all over the place, these justices. He says, look, I don't agree with Powell or Stevens. He said, I support the full application of international shoes to all assertions of personal jurisdiction, meaning that minimum contact test. It should apply to every form of personal jurisdiction. And so, it's a crazy case. The question is, does Schaefer overrule the existing precedent that you do not need minimum contacts for quasi in rem or in rem jurisdiction? That's really what we care about. Does it overrule how things have been done for the past 100 years? The answer is yes. So in order to exercise quasi in rem jurisdiction, the minimum contact plus fairness test must be must be satisfied. So again, yes, Schaefer just changed the law. They said that yes, in order to exercise quasi in rem jurisdiction, the minimum contacts plus the fairness test must be satisfied. So this is a big deal. They keep changing the law on us, right? So as of now, this is what we know. We know to file a case in civil court, you need proper service of process, meaning notice. You need personal jurisdiction, subject matter jurisdiction, and venue. What we learned in determining whether or not there's personal jurisdiction is you can establish personal jurisdiction by in rem jurisdiction, quasi in rem, which now also requires you to establish minimum contact and fairness, specific jurisdiction, and general jurisdiction. That's what we've learned thus far. Any questions? Yes.
So the minimum contact rule doesn't apply to in-rem, it's only quasi-in-rem?
Correct. She asked, does the minimum contact apply to in rem and not quasi in rem? And that is correct. It just applies to quasi in rem. But to be honest, it's kind of silly because if you have property in the state, you're going to have minimum contact with the state. You can make argument for the state anyway. But technically, no. You don't have to do that analysis, for example. Yes.
And as far as purposely availing, is that only for corporations doing business, like, so
No, purposeful availment is anybody.
anyone?
Yeah, so business or if you're, you know, I purposely avail myself to the state of Kentucky if I have a license here. Or even if I don't have a license, if I own property here. I mean, anything I do to make a connection with that state is essentially going to be purposeful availment.
But you don't have to pass that test with a quasi-in-rem?
Good question. So she's asking if purposeful availment applies to quasi in rem. Purposeful availment now is part of that minimum contact test. So they're now joining the hips. Thanks to Hanson. All right. I will post the readings. It is 10:15 on the dot, and I will see you all on Monday. No, I won't. On Tuesday. MLK. I have to school.
I'm staying here, right?
We have class.
I know, right?
What's today?
We don't do this right now.
10 minutes. My head is spinning. Oh, she lost it. I lost. I kind of got it wrong.
Okay, so
No, I didn't finish it. Like, I didn't read it. I read the cases. I'm reading my book. Yeah. Take your phone?